Welcome to Shenkman Education. My name is Marty Shenkman, and the topic for this video clip is pre-marriage planning. If you're planning to get married, there's a lot of steps you should really evaluate to make sure that you protect your assets in the event of a lawsuit or divorce later. Divorce is very common. I mean, the oft-quoted statistic, and I'm not going to evaluate it, is 50% of first marriages end in divorce and 75% of second or later marriages end in divorce. Even if that statistic has come down, which I believe it has in recent years, the potential issues are significant. And this doesn't mean you have to be unfair, unreasonable, or economically harsh to your spouse-to-be. It means prudently protecting what you have. Where you come out on that spectrum is certainly a very personal decision. Everyone, I think, is aware that you should consider a prenuptial agreement. A prenuptial agreement is an agreement between you and your future spouse before the marriage as to how assets will be divided in the event of a divorce. Sometimes those things become very adversarial. Prenuptial negotiations become adversarial. I've seen too many agreements where the spouse with more wealth is in my view, unfairly restrictive in what they negotiate. If I die, you get $100,000 of insurance coverage or per year of marriage. If you're young and healthy and you can go out and buy a large insurance policy, why not just do it and make sure that the person you're in love with that you want to marry will have adequate resources? Let's not get into the negotiations, but you should really evaluate getting a prenuptial agreement. Many people don't do it, I think in part because they feel it's a negative thing to do. It doesn't have to be. I've seen situations where it's done constructively, where a financial advisor or independent attorney, not a matrimonial attorney, helps talk to the parties about realities of finance, pre-marriage, post-marriage, and it can actually be very informative, very educational, and help the young couple, well, the couple, they don't have to be young, get on their feet financially and understand some of the legalities of what they're doing. So it doesn't have to be an adversarial negative process. Don't let it be. So step one is consider a prenuptial agreement. Another step. Let's say you have significant wealth, it's in your name, you've been working for decades and built up significant wealth. Before the marriage, whether or not you get a prenuptial agreement, and you surely should if you have significant wealth, but whether or not you get a prenuptial agreement, consider setting up irrevocable trust to hold assets. If you create an irrevocable trust, and you can even create what's called a domestic asset protection trust, the acronym DAPT, DAPT, it's also called a self-settled trust because you create a trust to benefit yourself. You can create such a trust, put assets in it, still be a beneficiary of it. You have to be in one of the approximately 20 states that permit that. And you could put those assets outside the reach of your creditors, outside the reach of your new spouse, outside of your estate, yet still be a beneficiary. And there's many variations of that. That's a powerful premarital planning step. Then if you do a premarital agreement, prenuptial agreement later, you can disclose, and different lawyers have different views of it. I favor disclosing everything and being above board, but you can, I think should, but others will differ, disclose the existence of the trust and what assets are in it. You've now been very fair and open with your spouse-to-be that, look, I've done this planning for general asset protection, general estate tax, and it's a good premarital planning step. So look at creating an irrevocable trust, and depending on your wealth level and how much you're putting in, you probably should evaluate different types of self-settled trusts and the variations thereof in case you're going to need access to it. Another thing, let's say you can't do those, or in addition to that, what assets you leave in your own name. Create a revocable trust for inherited or separate property. So I'm going to create the Jane Doe revocable separate property trust, and I call it that. And the only assets I put in are assets that I own before the marriage, and I do this before the marriage and frankly before the prenup, and I would again disclose it, although others may differ, but you probably should. And make sure you document that these are premarital assets that you earned on your own before the marriage. And that's important if you're living together with your spouse-to-be, your partner, that they didn't contribute to those assets. If you create a revocable trust, it doesn't safeguard the assets in the sense that if there's a later divorce, the court can force you to divest those assets. What it does, if you do it properly, is it helps maintain the integrity of those assets and avoids commingling. If you commingle or mix separate property from before the marriage with marital property, it becomes generally tainted as marital property and could be subject to distribution in a divorce. If you use a separate accounting entity like a revocable trust and just keep it there, you've at least maintained separate identity and hopefully preserve the premarital status, separate property status of that. Thank you for joining me, and please bear in mind that any of the video clips from Shenkman Education are for educational purposes only. Be certain to consult appropriate advisors before taking action. Thank you.